it's not just predictive. These things are already happening. And so let me discuss a number of the particulars. If you have a church hall that you lease out for weddings and you open it up to the public, you will not be able to have a rule that prohibits the conducting of same-sex weddings in that church hall. This has already been a case that happened in New Jersey. The conflict between state public accommodations laws and your religious liberty doesn't extend to being able to exclude people from a facility that you have otherwise opened to the public. You'll probably have a stronger claim not to allow the church facility itself, as long as you've only limited access to that to members of your congregation. But even that's going to pose problems for you down the road, because the way these issues have been framed going to Supreme Court by the other side, that there is no possible explanation for defending traditional marriage other than hateful bigotry against gays and lesbians, and therefore it will become the public policy of the state not to allow any institution to continue to adhere to that quote-unquote hateful bigotry. And they will start revoking tax-exempt status from organizations. I don't expect that they would begin with the churches themselves, but they will begin with the collateral organizations, like your charitable services operations or your youth services operations. Already in California, for example, we see a bill that's been introduced in the legislature that has every expectation of that passing through, that would revoke nonprofit status for purposes of state law from any youth group that excludes gays and lesbians from their membership or adult leadership positions. The bill is obviously targeted at the Boy Scouts, but it will apply to any church youth group if you would insist on following such a policy as well. And then you'll be confronted with, do we violate our conscience, or do we lose our tax-exempt status? There will be further moves as well. The accreditation process, these things will now become mandatory as part of the curriculum in the public schools. But I suspect in fairly short order, anybody that tries to avoid that mandatory curriculum in the public schools by going a private school route will find themselves at risk with the accreditation agencies for their private school system if they don't toe the official public policy line that will be mandated. And these things are not going to play out over a generation or decades. I think we're looking at these things coming fast and furious within the next 3 to 5 years.
Pretty sobering thinking that you're sharing here. By the way, if you have a question, go to info@4, that's the number 4, SD.net. info@4sd.net. Email that question to us, and we'll ask John Eastman. Eric Stanley, you're an attorney. If you want to come on with a question in just a moment, I'm going to go to Chris Clark, my co-host here. Chris, what question do you have for John Eastman?
John, just in keeping with the vein of thought here and the questioning, let's go the other direction. Suppose we get a favorable ruling. Supreme Court says that not only does California have the right to amend their constitution and define marriage as such, but so do all the other states. What are the implications for pastors in that scenario?
Well, I think you need to be prepared for the grand political fight, and you need to be actively engaged. And let me put this in the larger context. We had won 35 state elections in a row until last November, including most recently last spring in North Carolina, where the polls were showing that we were losing, and we won 69 to 31%, a decisive victory. We were outspent in North Carolina by nearly 2 to 1, and we won anyway. What happened in November in Massachusetts, in Maine, I'm sorry, not in Massachusetts, in Maine, in Maryland, in Washington, and in Minnesota, we lost all 4 elections. 3 of them authorized redefinition of marriage, and the 4th was a defeat of a constitutional amendment that would have protected traditional in Minnesota. And those elections, now, people, the press in particular, are taking those elections as this thing is over, the trend is all done, you might as well give up. And the strategy on the other side has been to demonize their opposition, and then now to demoralize and we cannot let that occur. And let me talk about that election, because I think it's a very fruitful inquiry for what's going to happen on the political front on the next ones. The pro-traditional marriage forces in every one of those 4 states last November were outspent by more than 4 to 1, by more than $20 million in the 4 elections. And yet the pro-traditional marriage result significantly outperformed the top of the Republican ticket in all 4 states by more than double digits. So the pro same-sex marriage fight won by much less of a margin than President Obama defeated Governor Romney in all of those states. And that means even in the most liberal, bluest of the blue states in the country, the push toward same-sex marriage barely won after having outspent the traditional marriage forces by more than 4 to 1. And that tells us that if the Supreme Court upholds Proposition 8 and upholds the Defense of Marriage Act, we're going to be back in a political battleground. But if we can come up with even half of the resources that they are able to deploy, we will win those battles in almost all of the states, and quite frankly, maybe even win back one of the ones we lost. It's critically important, therefore, that the sleeping giant of moral America, that is most reflected in the folks who attend church on Sundays, that they get active, and that means they're going to have the encouragement, enthusiastic encouragement of all of you on this phone call. We have got to get engaged if we're going to stop this, because otherwise, if Proposition 8 is upheld, I can guarantee you on the 2014 ballot in California will be an initiative to repeal Proposition 8. And we be prepared to fight that battle on moral grounds to prevent California being lost, because the sheer size of California would be a devastating loss. So these things are important, and they will come very quickly if the Supreme Court does uphold Proposition 8, because then the battle just shifts to the political front in an even bigger way than it has been there already.
So in other words, John, if we get a favorable ruling, we just need to buckle up because they're coming back again for another campaign.
That's right. And in the last go around, a number of major religions backed the pro Proposition 8 initiative heavily. We need to do that again, and we need to broaden the base. We need to have collections. We need to have the major donors that support your operations coordinated through this. The rank and file, the major donors, they get the bodies out. Every tool that God has given us at our disposal needs to be deployed to try and defend His understanding of marriage.
Well, I look to be ready, and I hope that our group will be ready when that comes. I have another question that's come in email. Here's the question, John. Can a church have a policy that defines marriages between a man and a woman? Can that give you clearance based on the religious belief of the church?
Well, one would hope that it would, that the First Amendment's free exercise of religion clause would give you some protection. But we've seen in the past that religious claims do not give protection if the courts determine that your claim is against or violative of public policy. And the arguments here have been structured so that adhering to traditional marriage is a violation of public policy. And so you will risk losing your tax-exempt status at some point, I have no doubt. Whether they succeed in that effort or not, I can't predict. But the effort will certainly be made to further isolate and demonize anybody that tries to adhere to traditional marriage.
Another question that's come in, now since Washington State has already legalized the redefinition of marriage, are we going to see a challenge right away because of that, regardless of what the Supreme Court decides?
That's from a Washington State pastor.
You know, I think it's possible. It depends on how strategic and thoughtful they're being. They may want to wait on those challenges until after the end of June when the Supreme Court issues its ruling, so as not to give new cause for concern to Justice Kennedy. But they might bring them now. You might well see applications for use of your church hall And then if you deny it because it's a same-sex marriage being requested, a complaint filed against you under the Washington State Public Accommodation Statute. I've not looked at that particular statute, but I have no doubt that there is one up there, and and those kind of complaints will be brought. There was a very similar issue with a church over in Atlantic City, New Jersey, a few years ago. And New Jersey was not even a state that recognized same-sex marriage, but a homosexual couple wanted to have a civil commitment ceremony in the church facility that they rented out to the public, and the church was sued under the public accommodations law for excluding based on sexual orientation, and they lost, and they were forced to allow that thing. And I don't know whether they did or whether they just closed down the facility, but those are not enviable options.
That's the Ocean Grove, New Jersey situation. I'm quite familiar with it because I've been on there and spoken there, been on that campus a number of times. It's actually a holiness camp meeting, one of the most beautiful in America. It's a pavilion right on the ocean, and the contention of the state was, since there had been state funds to help facilitate the maintenance of that beach there, that particular part of the shoreline, therefore, the church, the Ocean Grove Church, was hereby required to allow anybody in the public, including, in this case, 2 lesbians, for their commemorative ceremony. I think that issue is, I believe that is still going on in the court system, if I'm not mistaken. What's intriguing to me, John and Mary, Eric, you may want to comment on this too, is the officials of the Obama administration have made it crystal clear, a number of very forthright comments, saying that homosexual rights trumps religious liberty. The First Amendment simply has to fall at the point of affirming that homosexuals have exactly the same rights as anyone else. So they already demonstrated very clearly their feeling of religious liberty. Now, in the discussions in the Supreme Court, did it ever come up if it's going to be bona fide marriage equality? If it's bona fide marriage equality, the implications, for example, for polygamy or polyamorous relationships, did that issue come up that once redefined, then marriage equality would demand and dictate that anybody should have the same equality to define marriage however they choose to? Did that come up?
It came up explicitly. Justice Sonia Sotomayor asked Ted Olson, if we accept your view that marriage to whoever you want is a fundamental right, which other restrictions on marriage that we've previously recognized would have to fall? The ban on adult incest or on polygamy? And Ted Olson said, those deal with conduct, this deals with status, there's a difference, and he didn't answer her question.
I didn't catch the implications for that question, as you already stated. Thank you.
Yeah, but there are look, there are already cases pending making those claims. And if you just take it, look, if it's a violation of equal protection to discriminate on the basis of sexual orientation with respect to the marriage institution, well, that applies to a gay or a lesbian to enter into a same-sex marriage of 2. But why wouldn't it apply to a bisexual to enter into a same-sex marriage of 3, if that's the only way they can find adult fulfillment in their sexual orientation? And in logic, there is no difference. In fact, quite frankly, the number restriction on marriage to 2 would be seen as much more arbitrary than the gender restriction.
That's very interesting. This comes from Houston, Texas, where the pastor is asking, is it possible for you, John, or perhaps this would be an Eric question, to take the essence of the various options, in other words, the 1-state solution or an 8-state solution, and put them into talking points for pastors, very abbreviated kind of bullet talking points to help us as pastors grasp this. Is that possible to do in a very abbreviated document?
Yes, I could get something to you probably turned around within a day or 2.
That's great. Eric, what questions or what statements do you want to add to this? Your perspective is different from the rest of us as pastors. You're perceiving this as an attorney, and you're, of course, aligned with the Alliance Defending Freedom, 2,200 attorneys across America who are defending our biblical liberties. And by the way, once again, if I can give a commercial here, if you'll go to pulpitfreedom.org, pastors, we're asking you on June the 9th to join with us in solidarity, to sign up to preach on the topic of marriage. If you can't hit the June 9th Sunday because you're in a sermon series, then we ask you just any time in June or July or even May. But the bottom line is we'd like you to sign up there at pulpitfreedom.org. This is sponsored by the Alliance Defending Freedom. And the result is we stand in solidarity with each other, trying to educate America to the biblical truth about marriage. We could have marriage resources available to you. If you'll go to that